Okay, so look, obviously you can't evict a tenant because they drive a Tesla and you prefer Toyota, right? The whole eviction process can be a little confusing, especially if you're a new landlord. So what can you initiate an eviction for? Well, here are 3 of the more common reasons for initiating an eviction process in Florida. The tenant has either failed to pay rent, they didn't follow their lease's rules, like keeping a cat in their unit when the lease has a strict no pets provision, or they didn't maintain their unit according to the minimum standards set by Florida law. See Florida Statute 83.52. As well, it's worth noting that all cities in the state of Florida prohibit what's commonly referred to as self-help to push out either their non-paying or problem tenants from their units. Now, when I say self-help, what exactly does that mean? Well, self-help eviction is any action that a landlord takes to evict a tenant that is outside of the allowable legal means outlined in the state and local laws regarding evictions. This can look like a wide range of things. These methods include, but are not limited to, removing the tenant's unit doors, changing the tenant's locks and effectively locking them out of their unit, or interfering with the tenant's utilities, including cutting off their main water valve and other similar actions. And what happens if you do decide to take the self-help route? Well, tenants can sue landlords who take any of the aforementioned actions for monetary damage or statutory damages of up to 3 times their rent. Winning tenants can also sue for their attorney fees, and if they hire a lawyer on contingency, the lawyer can also try and sue to recover some of their fees. So basically, don't do it. To avoid all this stress, paperwork, and cost, here is the proper way to handle an eviction in Florida. First things first, you need to give your tenant a proper notice. You see, tenants cannot be legally ordered to vacate their residential units unless they have been properly notified at the beginning of the eviction process. And Florida state law provides for 3 types of notices. There's a 3-day notice, a 7-day notice with a chance to cure, and an unconditional quit 7-day notice. A 3-day notice is given to tenants who didn't pay their rent on time. To have any legal effect, your notice to a non-paying tenant must clearly state the exact rent amount due and give the renter 3 days to pay up. Keep in mind that this 3-day period does not include holidays or weekends. The notice must say that their tenancy is terminated if the tenant doesn't pay within the 3 days. And if the tenant fails to pay after the 3 days notice and doesn't move out, then Florida Statute 83.56.3 allows a landlord to start the lawsuit for the eviction process. Now, how about a 7-day notice of lease violation with a chance to cure? So most leases list terms of occupancy that the tenant is supposed to follow. Similarly, there are also tenant obligations required by state law. So landlords send out 7-day notices when the tenant has violated these terms. If the lease terms or statutory obligation violations can be corrected or cured, then the landlord must give the tenant a 7-day notice with a chance to cure. This type of notice lets the tenant know what terms they're breaking and that they have a week or 7 days to correct the problem. The notice also lets the tenant know that if 7 days have passed and the violation continues, that this would terminate their tenancy. An example of a lease violation that would warrant a 7-day notice would be like having 7 days to relocate a pet elsewhere in a no-pet building. Now, if the tenant has not resolved the violation within the 7-day notice period, per Florida Statute 83.56.2b, the landlord can go to court and file suit for an eviction process. The 7-day unconditional quit notice is for uncorrectable lease terms and violations. According to Florida Statute 83.56.2a, tenants can be found to violate lease terms in a way that cannot be cured or corrected. The law provides the landlords with an unconditional quit 7-day notice in these types of situations. This notice spells out the lease terms or statutory provisions that the tenant has violated and tells them to vacate their unit within 7 days, or they can face an eviction lawsuit. Once those 7 days are up, the landlord can go to court to continue with the eviction process. Other types of notices cover no lease tenants or holdovers. If a tenant hasn't signed a lease, then the landlord can end the tenancy without giving any specific reason. The landlord only has to send proper notice to the tenant, allowing for the number of days provided by Florida Statute 83.57. For instance, month-to-month tenants must be given 15 days to vacate. Since Florida state law does not automatically renew leases when they expire, tenants who continue to rent are considered leaseless. Accordingly, the notice process for month-to-month tenants that I just described apply to them as well. And if you're looking for your own Florida lease agreement, head over to DoorLoop's forms page and download your very own template, and don't forget to subscribe to make sure you don't miss out on all of the free resources we'll be giving you in the coming videos. You're going to want to make sure you're following the right method of giving notice to your tenants. So according to Florida Statute 83.56.4, Notices sent to tenants are considered properly delivered if they're hand-delivered, mailed, or if the tenant isn't around to receive the notice, then leaving a copy of the notice at the tenant's residence. In practical terms though, many judges require that landlords prove that the tenant actually received the notice. This means that landlords should use certified mail or require a return receipt when mailing out eviction notices. Still, the best method is to physically deliver the required notice personally. If the tenant isn't around, landlords must post a conspicuous and hard to ignore notice of eviction at the tenant's place. Once you've given the necessary notice period of 3 to 7 days, Florida Statute 83.59 enables landlords to file suit for eviction at the county courthouse with jurisdiction over the rental property area. To file suit, you or your attorney need the following documentation to file with the county court. You either need a complaint for eviction, a summons, non-military affidavit, or a double-stamped envelope for each defendant. Now, what should the complaint contain? The complaint must give the court all the information it needs to order an eviction. The landlord's information, the location of the property, the tenant's violation, and a specific request for eviction of the tenant. Landlords must also attach to the complaint a copy of the lease, if any, and a copy of the notice sent to the tenant. The summons is just the notice sent to the tenant informing them of the lawsuit. The affidavit of non-military status just certifies to the court that the tenant isn't U.S. military personnel on active duty. You see, different rules apply to active duty military personnel. If that's something you're interested in, leave a comment down below and we can make a whole video specifically about that. Also keep in mind that most Florida county courthouses require a $185 filing fee. In addition, there is a $10 summon issuance fee for each defendant. So before filing an eviction with the court, you need to issue the tenant a notice to comply. You can check the link in the description for our blog post about this, where you can find resources that you can either download as a free PDF or Word template, or you can create a Florida eviction notice using a step-by-step wizard that guides you through the entire process to make sure that you're submitting the legally correct notice. Now, the step-by-step wizard will ask you to pay a small fee at the end, but honestly, it is a small price to pay to ensure legal compliance and protection. I mean, the last thing you want is to go to court only to find out that you did the very first step of this process incorrectly. For the court to get personal jurisdiction over a tenant, the eviction summons must be served to the tenant. The county court clerk will send the tenant a copy of the eviction summons and the complaint, but as well, a copy of the summons and complaint must be delivered to the tenant in person. Landlords can either hire a private company or retain the county sheriff for personal process service. Typically, Florida sheriff offices charge between $30 and $50 per tenant to be served, while private companies can charge anywhere from $50 to $100 per named tenant in the summons. Now, once your tenant's been served personally with the landlord's complaint, the tenant then has 5 days to file a response to the complaint in writing at the county clerk's office. The tenant has to pay the court's necessary filing fee to respond to the lawsuit. If the tenant submits a response to the court, then a hearing is set up and a judge will be assigned to hear the eviction case. Landlords must physically appear on the date and time and show up at the appointed hearing courtroom. Bring whatever evidence, including witnesses who will give you testimony, you need to prove your claim. If you don't know what to bring, don't worry, we'll go over that in just a little bit. You can expect the county clerk to swear you in and ask you to promise to tell the truth, the whole truth, and nothing but the truth. Expect to provide your testimony to the court along with whatever documentary evidence you have that proves your claim. Keep in mind that at the very least, you are expected to bring a copy of your complaint, the lease that the tenant signed, and a copy of the 3 or 7 day notice. Should you be successful in proving your claims, the judge will issue a legal judgment declaring you the winner of the dispute. This legal document is then given to the county clerk's office. In turn, the clerk will provide you with a writ of possession. So what happens if the tenant does not reply? In the event that your tenant doesn't bother to answer the complaint, once 5 days pass, file a default judgment motion with the clerk of court. You will be given a motion hearing, time and date with the judge slated to hear your case. Appear at the appointed time and place. If all your paperwork is in order, the judge will conclude the hearing by issuing a judgment awarding you possession of the tenant's unit. This will be sent to the county clerk, who will then give you a writ of possession. For an eviction to be legal in Florida, the county sheriff's department must serve your tenant the writ of possession and execute it. You will have to pay a writ service and execution fee to your county sheriff's office ranging between $90 and $115. All writs of possession must include the landlord's full name and contact number of the land or the information of their authorized agent. Then either the landlord or their authorized agent must meet with sheriff's deputies at the premises of the eviction. Carrying out a writ of possession involves 2 steps: service and execution. Serving the tenant means the sheriff's deputy must personally deliver a copy of the writ to your tenant. If the tenant is hiding or can't be found, the deputy can just post the writ on the premises. Generally speaking, writs of possession give tenants 24 hours to leave the premises, but in more practical terms, writs usually end up giving tenants between 48 and 72 hours to vacate. This is due to the fact that everyone involved has to coordinate schedules, and writs can only be executed during normal business hours, which means no weekends. Now, once the deputy posts or personally delivers the writ, the deputy will then make a phone call to the landlord or their authorized agent to schedule a meetup at the property. The meeting is set after at least a full 24 hours have passed from the writ's delivery or posting. And then the deputy executes the writ. After at least 24 hours of the writ's service, the deputy will then show up to the premises and physically eject the tenant, assuming that the tenant is physically there. The deputy will also stand by and, if needed, keep the peace, while the landlord installs new locks or takes measures to secure the premises. This is meant to diffuse any tensions or prevent potentially dangerous situations caused by hiding tenants who might confront the landlord after the deputy leaves. The deputy is also expected to remain at the premises while the landlord or their authorized representative remove the tenant's possessions from the property. If the tenant has a lot of possessions, the landlord has to make arrangement with movers to quickly take out and remove the tenant items from the repossessed property. So at this point, you might be asking yourself, can a Florida eviction attorney help you? Whether you're a landlord or a property manager, evictions can be pretty rough. It's a complex process and mistakes can cost you a decent amount of time or money, or worse, both. For instance, you have to correctly figure out the amount of rent due when giving a 3-day notice. Depending on your lease's terms, you may or may not include the following in your rent total: late fees, insufficient balance bank fees, monthly surcharges for pets, storage or parking space charges, or fees for amenities like gym access or pool privileges. If you include any of the fees or charges above in your calculation of rent, the eviction hearing judge might invalidate the notice you gave your tenant. Your eviction lawsuit will get dismissed, and you will end up having to start all over again from the very beginning of the process. So if you don't want to risk that, contact an experienced eviction attorney so you can smoothly and correctly navigate the often confusing eviction process, save time, and gain some peace of mind. Remember earlier how I said you should bring evidence? Let's circle back to that. A lot of this stems in keeping good records, especially if the tenant disagrees with the eviction request and they reply to the court. It is essential that you keep extremely good records of everything so you can provide proof to the judge and win your case. This part is so important that it can literally make or break your entire eviction request in the event of a dispute. The best advice I can give is to stay organized. Keeping a paper trail can get very hard to search through, and it takes up a ton of storage space, and things can easily get lost, damaged, or stolen. Scan every document into your computer, and once you've scanned everything, make sure to back everything up using things like Dropbox, Google Drive, or you can use a property management software to save everything from lease agreements, signed documents, violations, emails, notes, invoices, payments, reminders, maintenance requests, pictures, videos. Not only can you use these to help you run other parts of your business, but this can be a great place that you can store all of your scanned documents. If a tenant doesn't pay rent and they dispute the claim, it's important that you show the judge the following. 1. Your lease agreement, showing the terms of the agreement, when rent is due, and any possible penalties for a late payment. As well, show them a payment history. Show all previous payments, how they were normally made, like check, credit card, ACH, etc., and what date they were normally paid on. Now, let's address some of the more frequently asked questions. Number 1, can I force a tenant to move out in Florida? Well, in almost every state in the US, a landlord must never try to force a tenant to move out of their rental unit. The tenant can only be removed from a rental unit after the landlord has successfully won an eviction lawsuit. Even then, the only person authorized to physically remove the tenant is a sheriff or constable. Essentially, Florida law has made it illegal for a landlord to personally remove the tenant from the rental unit. Question 2. What are the penalties for a self-help eviction in Florida? I cannot stress enough. Just don't do it. Just don't do it. But if you need to know, according to Florida Civil Code, you may be liable for tenants' court costs and attorney fees. The statute also gives the tenant the right to stay. Additionally, a tenant can sue you for damages plus violations. Tenants may ask for an injunction prohibiting any further violation during the court action. Again, if you're thinking about doing, just don't. No matter what the situation is, handle it the right way the first time, and I promise you it'll work out better for you in the end. And question number 3, any other Florida laws to be aware of? It's hard to say without going into specific jurisdictions, but I would review the laws on security deposits if you collected one. The security deposit usually protects the landlord if the tenant violates any of the terms in the lease agreement or causes damage to the unit, properties, or any sort of common areas. As I mentioned earlier, I'll leave a link in the description to our blog post where we cover all of this and where you can get a bunch of free resources and downloads. I know this was a long one, so thank you for watching. Subscribe if you haven't already. Let us know what state you're in, if there are any laws you want us to cover specifically, and be sure to check out our playlist where we are slowly covering eviction laws in every single state.